My last video regarding the new tenant laws drove a lot of feedback and additional questions. So here's some more detailed info specifically for landlords and flippers. I'm Keith Walker with the Walker team. The topics I'm hitting on in this video are violation damages, termination of leases, security deposit changes, and an upcoming new mandatory disclosure for flippers. Now, the Tenant Protection Act, TPA, has clarified its damages in the event that an owner improperly terminates a tenancy or raises the rent beyond the maximum amount. So effective April 1st this year, the punishment will be actual damages, reasonable attorney's fees and costs at the discretion of the judge, up to 3 times actual damages for willful violations, and punitive damages. Furthermore, the Attorney General may seek injunctive relief. The next law is in relationship to terminating a lease because the owner or a family member will be moving in. The termination notice now must state the name and relationship of the person moving in and inform the tenant that they can demand proof. Additionally, the occupant must move in within 90 days after the tenant vacates and must retain the property for more than 1 year. If that fails to happen, the owner must offer the property back to the tenant under the same terms and pay for reasonable moving expenses. Starting July 1st, there are changes to security deposits as well. Housing providers may only collect 1 month's rent as security for furnished or unfurnished properties. There is a narrow exception for small landlords who may still collect 2 months' rent as a security on any type of unit. A small landlord is a natural person, including a family trust or LLC with no corporate members, who owns no more than 2 investment rental properties, which collectively include no more than 4 total units. Now here's a hot one of the famous loopholes, if you would. Termination for substantial remodel has some substantial modifications. Hang with me here. The new law requires that the rehabilitation work would prevent the tenant from safely remaining and be required to vacate for 30 consecutive days. If at any point a tenant could continue living in the property without violating health, safety, and habitability codes, then the tenant is not required to vacate and the 30 days restarts. The notice also must now include a statutory notice, which must be written verbatim, that the tenant will have 1, a right to re-rent on the same terms if the renovation is not completed, 2, describe the remodeling to be completed and the approximate expected duration, 3, include a copy of the permits required to undertake the substantial remodel or demolition, and 4, include a notification that if the tenant is interested in reoccupying the unit after the substantial remodel, that the tenant shall inform the owner of the tenant's interest and provide to the owner the tenant's address, telephone number, and email address. Whew. Did you get all that? You can always rewind. Lastly, flippers. There is a new disclosure starting July 1st. A flipper is technically defined as any seller who is accepting an offer within 18 months from when they acquired the property and has since hired a contractor to perform work on the property. These sellers will have to disclose to the buyer all room additions, structural modifications, and any other alteration or repair that has taken place during their ownership. Furthermore, the seller either has to provide a copy of any permits obtained. And finally, if the cost of labor and materials was more than $500, the seller must disclose the name and contact information of each contractor who performed work on the property. Big Brother is watching. Be sure to dot your I's and cross your T's. As always, I'm Keith with the Walker team of Intero, here to educate and navigate, not speculate and fabricate. Need more information on how to navigate the investor market at your peak? Reach out to me for a confidential meeting.